Hello, everybody. Hi. I'm sorry I'm late. I'm sorry. I really tried. And I'm right now my keyboard and mouse are on the other laptop because I need to export the clip to my Palmy drive in order to put it onto this computer. So, it's been a day. Wow. I spent 3 hours editing this docket and I was so excited. And then so I get to the end of it, right? And I was kind of rush editing where I was just taking all of the space, the sound spaces out and time gaps and stuff. So I was rushing and I wasn't like the beginning part of it. Like I knew I wanted to stream it. It seemed interesting just based on what I saw. So I was excited about it for that reason. But I hadn't seen very much of it. Like I was going in blind on the majority of it. And so I get to the end and I'm like, okay, I got to at least hear, do they continue it? What's going on? So I play the last little sound bit and it's the prosecutor, I believe, saying, Your Honor, my next witness isn't scheduled until 1. And the judge saying, okay, court stands in recess. I have the part 2 clip, but it's going to be another 3 hours of editing. But, I mean, all hope is not lost. That wasn't the only clip for tonight. That was just, how I do the entire docket. That was the extension on the main clip, So, oh well. I will find where this was exported to. Where oh my goodness. Are you kidding me, world? Like, where did you put it? CapCut. Hi, Earl. Oh golly, I'm so sorry. I know I called it. I know what I titled it. So now I need to find it. Okay. So, in the meantime, while that's doing that, I am going to do this. Hi, Emily! Hi, crazy old lady. I got my Shelly babes. Oh, honey, you can keep dreaming. I don't think that's ever gonna happen. But, well, if it does, it does. But I would be perfectly fine if it just stayed me and my, 20 closest friends and then all the replay crew members. I'd be fine with that. That's life for me. You guys are hilarious. I don't know where you get this idea. Like, seriously. I appreciate that you think that could ever happen, but you guys are so funny. Hi, Philippines. We got a real small group tonight. Hi, Shane. Hello, Catherine Gaston. Oh, sweetie. I am so sorry to hear that. Oh, Catherine Gaston, you have my prayers and you have my love. I love you, sweetie, so much. And I hope everything goes well for you. Hi, Salty Buddha. Good morning. I hope you had your coffee. Hello, Tammy. Did y'all see the short that I put up with Ava earlier? Oh my gosh, it was so cute. So if you haven't seen it yet, I went out to get her and she had her head on the deck like this. And she was just standing there like, please, Mama, let me in. And so I zoomed in on her face, and then she's started running to get up to the ramp, and it was just so cute. And then she did her Chewbacca call. And like I said, on the videos, her Chewbacca call just sounds like a growl. But it really is a brrr. It's so cute. So cute. Oh my gosh, I love that dog. Oh, gee whiz, golly shucks. I'm keeping it PG. Hi, Foxtrot. Good to have you, sweetie. I hope you're driving safe. Oh, I found it. Hold up. Okay. Yeah. Cut. And go to Palmy Drive. And put it in this folder. Come on, computer. Don't fail me now. Why is it being slow? It couldn't be the 50 dockets that I have downloaded today. That wouldn't do it. Not responding. Oh, okay. Well, the good news. Let me close down this. Try again. The good news is I have another clip in the meantime, and you all haven't seen Ava yet, so we can do that too. Because, you know, like I said, she doesn't get second dinner anymore, because she gets treats, and treats are second dinner. And then there's Earl and Billy, and they're all over me to get their treats. Hi, baby girl. Do you know what Mama's doing? Do you know what Mama's doing? Huh? Oh, you're such a good girl. Mama is live. And you know what that means. She sure does. And so does Earl. Hi, come on over. You gotta come over this way. Well, no, you gotta come over this way. Okay, now come up. There you go. That's how it's done. There you go. There's the Ava, everybody's favorite. Everybody's favorite. Okay. Should we start with the chicken biscuit? I guess so. Hey, you're not supposed to do that. You're supposed to be gentle. Gentle. And then the pepperoni sticks. I like these because I can break them up into smaller pieces for her. And then it's like she gets more treats. Come on over. You got to come over here. And then you got to come up here because that's, everybody wants to see your sweet face. And it is a sweet face. Can you speak? Can you speak? Speak. Close. Speak. That was like a whisper. Oh, can I have my shirt back, please? Thank you. I don't want to give everybody that kind of show. Speak. 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 Good girl. Speak. Speak. Louder. Good girl. She's so darn cute. And then the bacon strips. They all have this like fake coloring line through them. Like, am I the only one that gets annoyed by that? Like, this one's peeling off of it, But, dude, we all know that it's the exact same thing, just dyed lighter. Ava, did you forget the bacon strip? Oh, wait. Wait. You are so funny. I bet you were going off to get a drink, all these salty treats. I think they're salty, probably. They're savory. They're savory. Yes, good girl. Yeah. I'll let you go get your drink of water now. I love you. Here, let me give you a kiss. Let me give you a kiss. Ah. Forehead kisses. Mwah. Love you. Oh. Earl, is it your turn? Oh, look at Earl reach for her. That's the cutest thing. Oh gosh, I wish you could see mine. It's just Earl. It was just Earl. It's okay. She's on edge because Billy's been in a mood. And so Billy's been giving harder than supposed to love taps with his talons. He's been doing it to me too, but I got him tonight. So I came inside and he had that look and he was flicking his tail. And I knew what he was planning because I know my cat. And I'm holding my coat like this, like I'm what are they called? Matadors. So I'm holding my coat and I'm watching him and I could see him like get ready to lunge. He's like he's doing the fake out thing. And I'm like, I know the minute that I turn my back, he's gonna attack my leg. And he draws blood. So I'm like, oh, I've got a coat. And I just tossed it over him. And then I came to my room. And a little while later, he comes and he jumps up on the desk and gives me hugs and stuff. So it worked out. It worked out. But it was so funny. Okay, I think I just had too many programs open at once. Because I got it now. I thought I deleted those because I know I ran them. But they're still on the drive. I must not have done it. Earl, honey, why? How come you're not up to get your treats? How come you're not up here getting treats? You beautiful boy. You're such a beautiful boy. Okay, it's transferred, y'all. Yes, Earl. I have them. You just have to come get them. All right. Yay. See, I feel bad because it's like, hold on. There we go. I had to switch my mouse to this. I love my wireless keyboard and mouse. I absolutely love it. It was a gift. I believe, I might be wrong. I believe Jenny Green got it for me. If I'm wrong on that, I'm terribly sorry. But it was a gift, and I can switch my mouse and keyboard between 3 devices. I only have it hooked up to my 2 laptops, but if I wanted to put it on something else, I could. But it's so great. I can just click the button however many times to get to whatever device, depending on where I'm on. So, I love it. I love it. I love it. I love it. Because now I'm on my computer. There's nothing to switch out. You know, I've got the USB in that one, and this one I've got hooked up to Bluetooth. So now it's switched. All right. Rocky Horror Muppet Show. That's funny. I don't do a lot of TikTok. Well, I don't do any TikTok. Every once in a while, people will send me something, and so I have to, watch it on there. But I've been thinking about trying to upload my videos like to all platforms all at once, but I'm so unfamiliar with other platforms. The only thing I know is YouTube, and the only thing I know is StreamYard. So I have to figure out how to make this work. Yes, and see, everybody loves Ava. It was not 2 treats. It was 2 chicken biscuits, a pepperoni stick, a bacon strip, and she'll get more later. Oh, see, I'm really late for the US, and I'm really early for you. Hello, Shelly babes. Good to see you, love. Yes. And mine's cold. I don't know why. I just grabbed it off of the Keurig, but I don't remember when I made it. It hasn't been very long, but I've been dealing with that. It's been about an hour. So, yeah, it makes sense. See? I'm not the only one. The clicky button. Yep, mine is. So here's my switch between devices button right here. Over here, this is the evil eject button. One of them is forward and one of them is back. This one right here. This is the evil eject button that if it gets bumped, the whole stream closes. Yep. So I have to be very careful to keep my thumb far away from it. Lick the like button. Yes, see? I'm not the only one. All right, so I've got both clips ready to go now. We've got 11 people here tonight. It's going to be one of those comfy, cozy, quiet streams. Maybe everybody else will show up in a little bit. We're missing a lot of people. We're missing like 10 of our besties.
Case number 23S00968. SM, people of the state of Michigan versus Cario Breyer
Robert Shockley, on behalf of the people.
and Mr. Lane is no, Christopher Lane. He's on the sentencing and on Mr.
Yeah, she's in the hallway. I told her twice that,
She's a woman here for me.
yeah. It's,
Well, we're gonna pass that, Mr. Breyer, and we'll pass Patrick Trap Hedge too.
let me, see if I can convince her to remember that. It's not.
We'll just start the other matter and break when we can. All right, this is case number 23M00490FY, people of the state of Michigan versus Charles Walker. Well,
Elizabeth Lippett, on behalf of the people.
thank you, Ms. Lippert, you're in the building and in the room. Let's see, Mr. Nahikian is on this matter, and is he outside with Mr. Walker?
He's here. Agent Dulce's gonna go see if he's out in the hall.
Okay.
They have lost all of their defendants, witnesses, everybody. They can't find anybody. They're now going out into the hall. They know one of them is out in the hall and is just too scared to come in. And so she's passing cases because, I mean, what do you do?
All right, so, this one, we just called the Walker case. We can't find anybody.
No, this is Mr. Breyer, Judge.
Okay, well,
Let me go find this guy.
there he is coming now. Right, I don't have a pre-census report, so let me do this other one.
Right here, Judge.
And I said,
The attorney was looking.
let's do case number 23S01082SM. People State of Michigan versus Patricia Trap Hedge.
Robert Shockley, on behalf of the people.
Good morning, Your Honor. Mary Rubio for Ms. Hedgepeth. With her permission, I'm standing in for the attorney of record, Christopher Allian. Is that right? Okay.
All right, and so what's your name, ma'am?
Patricia Trap Hedge.
All right, and so today is the date scheduled for a pre-trial. And this is on one kind of stalking, a 1-year misdemeanor with up to $1,000 in fines. And we were here last, so attorney could prepare a deviation letter. So was that received?
Yes, and the people made a deal to plead to malicious use of a telecommunications device, a 93-day misdemeanor.
Your Honor, I did speak with my client. It is my understanding that she wishes to avail herself of that offer.
Okay,
And I do have a victim here in attendance today. He would not be opposed to being so.
do you have the PAC code?
Yeah, let me pull it down.
It's a 93-day.
Correct. It is 750.540E.
Is that a small e or a parent e?
small e.
Okay. All right, so, Ms. Trap Hedges, you're gonna be waiving your right to have a trial on the original charge of stalking, and you'll enter a plea to the added count of malicious use of a telecommunications device, which is a 93-day misdemeanor. And I'm gonna go over all of the constitutional rights that you normally would have at trial, that you are now getting ready to waive because you're pleading. And if you understand these rights, then all you need to do is say yes as we go over these rights together. So we're gonna start with the fact that, again, which is right. I'm sorry, that's okay. All right, so ma'am, we're gonna start with the fact that you have a right to trial by judge or by jury with your lawyer representing you. You understand you're gonna be waiving that? Okay. Ma'am, you're taking the plea. I'm trying to go over the rights with you. Did you hear anything I said or probably didn't? Did you?
Yes, I did hear what you said.
Yeah, I'm trying-
I don't understand.
I'm trying to go over the rights that you normally have at trial, that you're getting ready to give up because you're pleading guilty.
Oh,
Okay, so you are giving up some rights, and I gotta make sure you understand what they are.
okay. What am I giving up rights for?
Because you're not having a trial, you're pleading guilty.
Oh, okay.
Yeah, so if you plead guilty, you're admitting you're guilty of something, that means you don't have a trial. So you're giving up all the rights that you normally would have had at a trial. That's what we're gonna go over.
Okay.
Okay, does that make more sense now? Okay, good.
The judge is really trying to keep her patience. And I don't think it's intentional, but this woman's really trying the judge's patience.
So of course, now you know you have a right to trial by judge or by jury on the charges. You're gonna waive that, you understand?
No,
What?
I don't want to be bothered with all that.
Okay, so you wanna waive that, say yes or no? All right, and at the trial, you also have the right to subpoena witnesses. So you understand that you would have had a right to ask the court to order any witnesses that you would like to come forth to testify on your behalf. So you're gonna waive that right?
I'm waiting. I had some, but I'll wait.
Okay, and you also would have had a right to question any of the witnesses that are brought against you at trial by the prosecution. So you're gonna waive that. You also have a right to testify at a trial on your own behalf, but if you chose not to testify, no one can hold that against you. You understand? You're gonna waive that. Okay. And you also understand that you have a right to be presumed innocent of any charges unless proven guilty beyond a reasonable doubt by the prosecution. You understand? You're waiving that. Yes, okay. Now, if you're on probation or parole status somewhere at any court and you are pleading guilty today, the plea could be considered a violation of probation or parole because it might be considered a new case. So you understand that?
Can I ask a question?
Sure.
When this was first brought to me, I've never done a crime, okay? I mean, as a kid, I might have done some stuff, but I've never been in jail before or anything like that. They fingerprinted me. Okay, does that mean I did something?
Yes, ma'am. You're gonna be convicted.
I'm gonna be convicted of what?
Malicious use of a telecommunications device.
And so what does that do to me?
What do you mean, what does it do? It's on your record, so I don't know what it'll do. If you choose to go to get a job and someone says, oh, I don't want any misdemeanor convictions, that could affect you that way. If you were going to get some type of license from the state, and I don't know what, real estate, mortgage broker, doctor and lawyer, anything
I
that
would be able to
requires,
get another job if I wanted to.
ma'am, that would be up to the employer as to what their, expectations are. They might do a background check. They might be able to see it. If you're looking for a license, it could affect your ability to get that kind of a license. Maybe, maybe not. I can't say for sure, but it's out there to be seen, just like anything on a record. So you understand that?
Okay.
The only other option would be to go to trial and hope that you're found not guilty of anything.
Because I was thinking about going back to get a job. That's why I'm wondering if it will that.
Well, it just depends on what industry it is and whether they do background checks and whether they ask you a question on the application that you have to answer
Okay.
that, truthfully. So, all I can say is some crimes are more considered than others, and I don't know where this one would lie. As far as what an employer would think if they saw it. Some have blanket policies, no record at all. Others, as long as it's not violent, they might say, okay, I don't really know. But, it's just there for them to see, and you should be aware of that. So, okay. So you still wish to continue with your plea? Yes, okay. So, we were talking about, if you were on probation or parole and you pled guilty, this could possibly be a violation of probation or parole status. So you understand that? Okay, but you understand that anyway. All right. And so you read and signed the advice of rights with your lawyer just a minute ago. Did you have any questions about any of the rights? Understand that if I do accept the plea, you will not have a trial of any kind, and you will be giving up all the rights we just went over that are on that form, with the exception of a right to appeal. If you have a right to appeal, you must do so within 21 days of sentencing and request a lawyer within 14 days of sentencing for the appeal. Other than that, you're waiving your rights. You understand that? You have to say the word, yes. I mean, the grunting, I don't know what that means, so you have to say a word, okay? And you also understand the potential penalties involved with this charge of malicious use of a telecommunications device. 93 days and a $500 fine. Well, apparently, let's see, 540E,
That's right.
6 months or $1,000 fine, is what it says here. That's the possible penalty. So you understand that?
Yes.
And you still plead to that charge?
Yes.
Let's see, anybody force or threaten you? Did anyone promise anything to you other than what was stated on the record?
Today?
Yes. And are you pleading freely and voluntarily?
Yes.
Did you just mean to, let me think. All right, well, we're gonna go with 540E. All right, so did you on or about the date of, let's see, March, somewhere between March 24th of 2023 and November the 9th of 2023, Ms. Trapp-Hedges, did you maliciously use some type of service provided by a telecommunications provider with the intent to frighten or intimidate or threaten or harass, annoy, molest,
No.
terrorize a person or disturb the peace and quiet of the person?
I never terrorized it.
Your
Never.
Honor, may I have my client?
Let's put this in perspective, y'all. From March to November, 8 months. She was facing a stalking charge. 8 months. She put this woman through this. And now she's saying, I didn't intend to annoy her or harass her. That wasn't my intention. If somebody tells you not to call them and you continue doing it for 8 months, that's annoying and harassing and stalking.
Did you hear the dates that the judge just mentioned, sometime basically between March of 2023, March of 2023 through November of 2023? Is that correct, Your Honor?
Yeah, March 24th, 2023 through November 9th, 2023.
Okay, did you hear those dates? Sometime between those months, did you make telephone calls to a woman named Cassandra Smith?
Yes.
Okay, and at some point during that time period, did Ms. Smith tell you she did not want to talk to you?
Yes.
And at some point during that time period, did you call her after she said that to you?
Yes, because
Okay.
I want to close.
I understand.
Okay, well, ma'am, and so in that sense, you use the phone to at least annoy her. Is
I
that?
wasn't trying to,
Okay.
I was trying to tell her the truth.
Well, ma'am, does she
But-
want to talk to you?
No.
So then do you think that would be an annoyance? If somebody keeps calling you, you don't want to talk to them? You don't think you're annoying her?
But the first.
Okay, well, then you need a trial here,
No,
man.
I don't wanna,
No, cause I can't, I gotta make some kind of basis for the
well,
plea.
make it like,
Ma'am, I gotta make a basis for the plea, and if I don't hear that you're not trying to disturb the peace with her, you're not trying to annoy her, but you continually make her, I don't know what you're doing. So I need to have a trial.
Your Honor, I think that initially, my
She
client.
charged her with stalking.
Correct.
This is way less than that, and she's saying she wasn't
Absolutely.
even trying to do that.
Absolutely. And I think initially she was under the impression that she had a good intention, and I did explain to her in the hallway, it doesn't matter because it gets to a point where if the person says they don't want to hear from you, there's a reason they don't want to hear from you. They're either annoyed or they're bothered or harassed in some fashion. They find it harassing. I think that maybe perhaps my client's having a hard time envisioning what someone else is getting in their mind. But ma'am, would you agree if someone doesn't want to talk to you and you keep trying to talk to them, that person can find that annoying or harassing? It doesn't matter what the reason.
yeah.
People satisfied.
The people are satisfied and believe the court rule has been complied with.
All right, defense, you satisfied?
Yes, thank you.
And I'll be satisfied as well. And I'll find this plea is freely understanding, voluntarily, actively, knowingly made. We'll go ahead and dismiss the stalking pursuant to the plea agreement.
And Your Honor, I believe the prosecution does not have any opposition to immediate sentences that.
I do not, the victim present is dead.
Do they want to speak?
Yeah.
Yes, no?
Yes.
Oh, okay. All right, ma'am, come on up and tell us what your name is.
My name is Cassandra Smith. Good morning, Honorable
Good
Judge
morning.
Sheila Johnson, as well as everyone else in the court.
Okay.
I find this very insulting that it's a malicious charge of use of telecommunication device, but I clearly sat there and understood everything. Considering that this lady, she called my son's phone first, left a message. She called me. I did have a conversation with her, and I asked her not to call me. She called me on my job. Saw her at a restaurant. She followed me out of the restaurant, walked around my car, came to my home, my sanctuary. The first time, before I could get outside, she had gotten to the car and pulled off. 2 weeks later, she shows up again, walking around my house. However, this time I was able to talk with her. I told her to get off my property. Again, I expressed I did not want to talk to her. Again, she's telling me all these lies that she had told me before, same thing. And there's been so much, it's almost been like a lifetime story. Lies, planning, and plotting, because a couple of my friend enemies have been feeding her. On my job, you know, she has a friend enemy who's spreading things, just unbelievable. So my thing is this morning is, I'm a person of happiness and joy as well as peace. You can tell someone you want to hurt me, but you're not going to hurt me because I'm covered. I just ask that you not ride past my house again. Do not come to my house again. I wish you well. I wish her well. I have nothing to do with her, nothing against her. I don't know her, even though she violated my life by coming to my house. My neighbor's looking. My neighbor's asking me questions. You know, and at this point, it's a cold-hearted world, I understand that, but life is too short. I've lost a lot of people, and that's the other thing. I lost my husband in 2020. This lady has called people that my husband worked for, inquiring about me. If that's not lowball, I don't know what it is, but I stand on the principle of our former First Lady, Michelle Obama. When they go low, you go high, and that's what I will do. I will not chase a man. I'm not coming after a woman or a man. And all of this is over a man. So at this, exactly. So at this point, I just ask that Ms. Hedgepath, please don't call, don't come by my house, and frankly, keep my name out of your mouth. Thank you, Judge.
All right, well, you know.
Man.
I appreciate Ms. Smith being here to give the court a full.
Oh, and real quick, let me wish you happy Women's History Month, because I know that you are the first Black female judge here.
Oh, thank you.
Because I salute you.
Appreciate that.
May I address the court?
Yes.
Your Honor, Ms. Hedgepath is 74 years old and has no criminal history.
That's why it's surprising
And
that she would be involved in anything
It
like
is.
this, especially over a man.
It is,
I mean, at this age of wisdom, You
She's
know
also
better.
a widow.
Because it's, what difference does it make at this point in life? It's like if you can't get somebody and they're not treating you the way you wanna be treated, or they care for somebody else and they wanna be with them, then you just gotta move it, keep it moving. Because life's too short for that. And there's other people out there that will treat you the way you want to be
And I
treated.
know that. That's the exact truth. The first time I talked to her, I told her nothing but how I had been used and, you know.
Okay, well, she could probably appreciate hearing that one time.
And I told her I was still in love with my deceased husband. No, I told him that when okay, I don't want that man.
But then why you keep calling?
Because he owes me.
This lady has nothing to do with all that though.
Ms. Hedgepeth is, as you can see, pretty, in my opinion, understandably upset about being bamboozled out of some money from this gentleman. And I think she's kind of got it wrapped up with this situation. She actually has a civil case pending with that man. I think there's a lot going on, but I've expressed to her that regardless, this woman, Ms. Smith, does not want to hear it, doesn't want to be a part of it. But I would ask, Your Honor, I think that at this point, I think Ms. Hedgepeth more than understands that. And I would ask for the very minimal sanctions possible, considering her age and her lack of criminal history.
Is she working? She
No.
says she's looking to.
No, because he bamboozled me out of so much money that I'm looking for another job. I do not want him. I told him to his face, I am in love with my deceased husband who treated me like a queen. This man never treated me like I expect a man to be treated. She told me how good he was to her. I didn't question that. I didn't care. He is what do you call it, a pathological liar.
Well, you certainly cared in some way. I think, Becky D, I think, and I might be wrong on this, but both women lost their husbands because she just said that she's still in love with her deceased husband. The other lady mentioned her husband had passed. So both women lost their husbands, and both of them got entangled with this new man. And it sounds like he was just taking them both for a ride. She got taken for the financial ride. It sounds like the other one got taken for the funsy ride. So, yeah, because they said that she's got him a case against him in civil court. If he was passed, then there would no longer still be a case in civil court. But that's just what I've been able to piece together. And I might be wrong, but that's my interpretation of all of it.
And he said he smear campaigned me. He smear campaigned to me. He smear campaigned her. I don't want him. Why would I want somebody who lies, cheats, and bamboozles people out of money? I don't want him.
Okay. But I guess the question is, if you don't want him, what's the problem?
Because I was trying.
Why are you talking to Ms. Smith? More
Because I
than
want
once.
closure. I want closure.
Well, ma'am, but she don't have any closure to give you. She's just another party to the whole problem. So what closure can you get? The only person that can give you closure is him, and you have to close that yourself. You can't wait for him to do that. But she's just another person that was involved with him. How can she give you closure? She said she don't want nothing to do with you, him, the whole
Oh,
situation.
she wants to be with him,
Well,
and she can have it.
If she does, fine,
That's
but,
fine.
but ma'am, you can't keep calling her. You can't drive by her house. You can't go to her job.
You know what I did for her? I wrote a letter because the people she's talking about, some girl, because he had told me.
Okay.
This man told me, yeah, I can't remember the name of the girl he told me, because I never have lied about him, but I lied to him because once I found out what a bad liar he was, I'll be truthful, I started lying to him left and right, just like he was playing the game with me. Now, he told me about she and a friend.
Man, why we getting into all of this though?
But that he knew who was telling me.
But ma'am, what does the court need to know this for? This is a sentencing for you, not what he said to her, what she said back. None of that matters. What matters now is that you need to get beyond all of the madness. This is madness on some level.
I will not have.
And
anything
you-
to do
you
with her.
just
She can
need-
handle that mess herself. I have nothing.
She,
to
and
do.
she will. She looked perfectly capable of handling her own business pretty well to me. So you just gotta let her do that. Leave her alone. You heal from whatever wounds you had from the
I
person
have, I've been betrayed
and
and
move
used,
on.
betrayed and used, very bad.
But now you know, now you're stronger because of it.
Yes,
Now
I
you
learned.
know what to look for
You're right.
and what to be aware of the next guy you meet, and you won't be vulnerable like that anymore. That's the lesson you got
God
to
has
learn.
taught me a lesson.
That's
God,
the
I
lesson.
prayed about this and God told me, you know,
Okay, so,
I have prayed.
all right, so I don't know where Ms. Smith
I
lives,
learned a lot.
but I am gonna say you can't be around her or her address, whatever it is. So the sentence of the court, unless the people wish to be heard on this,
No, Your Honor.
all right. It's gonna be a period of 12 months of probation. If she's successful in doing a few things, she can ask to be released after 6. The fines are gonna be a $350 fine, no jail time. She'll do 3 days of community service at a nonprofit agency, no alcohol, no unprescribed drugs. No contact with Cassandra Smith or her address, which I don't have to put on the order. Do not, actually, let's obtain some employment, so as you said, you're looking. And I am going to order an evaluation and counseling if necessary.
I need some counseling.
Okay, well, we're gonna order a mental health evaluation and some counseling. It could help you.
I think that is very necessary because anyone who gets this obsessed and can't let go this hard definitely needs some counseling, be it grief counseling because she lost her husband, or be it, you know, that she needs counseling to get over the heartbreak of the, you know, of the man that didn't want her, or the financial loss that she took by, you know, treating the man. Whatever it is that she needs counseling of some sort. So I think that was a very smart move on the judge's part.
And there's gonna be a $75 crime victims' rights fee pursuant to statute and a $200 counsel fee.
Your Honor, would you like the victim's address for
Yes, for the order,
the mayor approach?
yes. Okay.
Your Honor. When you have a second, may I address one of the things that you are putting in the order? I know that she does want to get a job, but I'm a little concerned that with her age, she may have a difficult
Oh,
time.
they got greeters at Walmart of age. There's the jobs out there.
I
So
was
she's
going
fine.
back into education.
Well, she might be able to substitute.
Great.
That's what I was
Thank you.
thinking.
Yeah, she might be able to do that. They're looking for folks to do that. Yeah, I don't like age discrimination.
I don't either.
So people have gifts and talents that they can do well into their 80s and 90s sometimes.
And I've been bamboozled out of so much money.
So you'll get some type of employment. All right, so that's gonna complete the sentence of the court.
Thank you.
All right, and here's the file. We'll wait for the probation order, then take her down. So you're all set. Case number 23S000968 SM, State of Michigan versus DeCario Bright.
Robert Chocolate on behalf of the people.
And Mayor Rubio, on behalf of Mr. Breyer, standing in for his attorney of record, Christopher Allian, with his permission, is that correct, sir?
Okay, and what's your name?
Carter Breyer.
All right, so we're here for sentencing on a domestic violence second offense. We do have the pre-sentence report here, and is it factually accurate?
I believe so. Yes, sir.
Okay, would you like to make any statements on his behalf?
Yes, Your Honor, first I wanted to ask the prosecutor if he remembers, I spoke to Mr. Allian, and he was under the impression, he thought had been a COGS evaluation, but he didn't.
No jail, but maybe a jail alternative with a work program.
Okay, great, because I was concerned when I saw the recommendation for 13 days jail, Mr. Breyer has 3 children to provide for, and I just, in talking to him, he also has since lost his mother. This incident was regarding his stepfather, and unfortunately, since his mother had passed away, he now has no reason to interact with his stepfather. We ask the court to, if it's possible, to forego the jail portion of the recommendation.
Okay, anything you wish to say, sir?
This incident, happened from being over at my mother's house. I don't have no prior history really of criminal activity or assault or whatever you want to call it. I no longer will be at that apartment no more, to be around my stepmom.
Well, what about the domestic violence from 2021 that you had?
Yes, I mean,
It was against.
that was in that same apartment.
You said you really didn't have any history. Well, yeah, you do.
Yes, sorry.
Yeah, other than that, Judge, sorry, I slipped my mind. You know, the only other conviction that I have, I forgot all about it.
And you were drinking. How much did you drink?
Not a lot.
Well, what does that mean?
Probably one.
One beer, huh?
Not very long.
Get around, I wanna watch you.
People wish to be heard.
Yes, Your Honor, this incident, the people's perspective is the product of maybe some anger issues and alcohol abuse for that matter. When the police entered the apartment, they told him to leave. He went in the kitchen, grabbed a bottle of wine, took a nice big sip of it and said no. So, it's not a little bit.
Okay, thank you. And the complaining witness, what is his name?
Frank Maxwell.
Mr. who?
Frank Maxwell.
Yes, and Mr. Maxwell was offered to come here today and he stated to me that he did not want to make a statement.
All right, so this is within the CAB's evaluation that the court gave. Sentence of the court's gonna be 24 months of probation. This is not the first, but it is the second domestic violence offense. Apparently coming out of the same circumstance, so obviously counseling and remedial measures and punitive measures will be necessary. So $960 of oversight fees, fines will be $500. 13 days is the jail sentence credit for one. As an alternative, we're gonna do 8 days in the Southfield work program. And I'll suspend the other 4 days that would be in jail if he is in compliance. So he's gonna owe me at least 4 days in jail, if not more. He'll do 3 days of community service at a nonprofit agency. There'll be an alcohol substance abuse assessment done, treatment if it's necessary. There will be no alcohol or unprescribed drugs, drug testing. He'll go to an AA meeting once a week. No contact with Frank Maxwell or the residents of Mr. Maxwell, which is, do not go there, and that is in Southfield. Also obtain the GED, maintain employment. There'll also be an extended 22-week anger management class, and they're asking me to send them to the HEAL program. So we'll do that as well. $75 crime victims' rights fee and a $200 counsel fee. And there's also a PSI assessment fee of $100. And that will complete the sentence of the court. So there is no jail unless he makes it a jail term by failing to do some of the things that he's required to do. All right, here's a bond, $250. Rebecca Hurd posted it. She can get it back or apply it. Is she looking for it back? Is she gonna apply it?
I'm looking for it back.
Okay, we're gonna refund that. All righty, clearly. All right, you're all set. He'll take it out to probation. Good luck, sir.
And then after that case started another mess of a case. And that's the one that went on for, it was little over an hour, and so it took about 3 hours to do the editing, and then when I got to the end, and they said on the next docket, which, like I said, I have it. It's going to take a lot more editing. So I had to clip that part out. Ooh, which reminds, oh shoot. Oh no. When my computer did the not responding, I closed CapCut, which means I deleted all of my editing that I did on that docket. Because normally, like, when something like that happens, I'll highlight everything that I've edited that needs to be taken off, and then I hit delete, I export the file, and then I go back in after it's exported, and there's an undo button. So I undo it, and then I take the stuff that I've exported and I erase that, and then I'm left with just what I've edited, and I can save that. But because my computer did the not responding and I had to close it, it's no longer in the clipboard, and I've lost it. I just lost 3 hours of work. Tomorrow's going to be fun. Yeah, I did that. Yep. Oh, man. That hurts. That really hurts. Wow. Oh, okay. And that was the reason I was late tonight, was because I was working on that, because I so badly wanted to get it done so I could show you guys. Oh, I'm mad at myself. I really am. I'm mad at myself. Now I have to redo all of my work. That's what. That's all I can do. I either say, yeah, it's not worth it, or I, pull myself up on my bootstraps and start over and do it, which is probably what I'll do. Thank you so much, Tammy. Oh, honey, I love you. You got to let me know who you hit, because I don't get to see it. Yeah, well, and here's the thing. I know I have it. I know what it is within reason. I didn't watch all of it, but I know the general gist of it. I don't know. Maybe it gets boring after the, first 20 minutes. I don't know. But I know I have it, so I can go back and do it anytime. Oh, Shane, thank you. You guys are so awesome. Thank you, Shelly babes. I appreciate that. Yeah, we all goof. It's, Hey, you know what? The good thing is, y'all see all of my mess ups all the time. So, and very often they're relatable. Like, so many of you can relate to my mess ups. So me being here lets y'all know you're not alone. I am happy to share my screw ups with you if it makes you feel less alone. Oh, golly. Woohoo! Nanner news. I'm gonna try not to. Oh, yeah, I'm gonna try not to. You hit Kenya Brown. Yay! Missy B got one. Nice. You guys are awesome. Yes. Green and blue. That's my chat's colors. Hey, you know what? When there is a gray person in the chat, you know what that means. Seahawks colors. Green, blue, and gray. Where is Palmyra when I'm talking Seahawks? Nicola, honey, hi. How are you, sweet love? So good to see you. Yeah, at least y'all know I'm not AI. I do have another one. I feel sad though, because I don't have this is the last one that I have. Editing takes a while, and when you dump all of your energy into something that doesn't work out, it sucks because now I only have one more clip because I ran all of my extras last night. That's all right. We'll find something. We'll find something to do. Oh, wait. Oop, whoop, wrong folder. Here we go. Yeah, this one is, how long is this one? Don't you freeze up on me, computer.
Mr. Traxler.
It is, Your Honor.
People versus Traxler, case number 2348878. The record should reflect that Mr. Traxler is present here in court. Counsel, your appearance is on.
Ryan Ziegler on behalf of DJ Matt.
Counsel, Grant with on behalf of Mr. Traxler. This is the date and time set for a sentencing hearing in this matter. Mr. Traxler, have you had a chance to review the pre-sentence report and go through that with Mr. Seeger? Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your Honor, no challenges to score either.
Thank you. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do people have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people crowd?
Your Honor, this defendant is a young man, became involved in a, for lack of a better term, a conspiracy involving a large number of thefts of certain personal property in the area. When he was caught by police at the time of the arrest, he was cooperative. He told the police where the generator they were looking for was. He's been relatively compliant with law enforcement. He's appeared at most, if not all, of his court dates. I do think he's a good candidate for Holmes Youthful Trainee status. I think it's appropriate given his young age and his relatively good cooperation with the arrest and the police questioning at the time of his arrest. So for those reasons, Your Honor, I would ask the court to adopt the recommendation, sentence him to Holmes Youthful Trainee Act, and give him an opportunity to demonstrate to the court that he still can reform his life and turn the situation he's found himself.
All right, thank you, Mr. Seeger.
Yeah, likewise, I would just ask the court to give him the benefit of HIDA. The only question is whether or not the court would impose any additional jail time. He did spend 43 days in jail currently, or at least that's what the pre-sentence report reveals. I did speak to probation and parole about this particular file. I think Ms. Wagner had some reservations about initially conceivably giving him the benefit of HIDA because there have been some unsuccessful discharges, and he is somewhat accumulating in criminal history, which is concerning. But when the offer was made, all of these things were known to the prosecuting attorney's office. Part and parcel of the reason why the offer was extended was, one, because he was cooperative with law enforcement, and two, at some point in time, he did make a truthful statement relative to his involvement and maybe that of others. But be that as it may, Your Honor, I agree with Mr. Ziegler. He's a young person. He can learn from this. He does have a family to support. He has been doing much better, at least from the time that I initially had met him up until the date of sentencing. He has been in continuous contact with me when a lot of clients who, for whatever reason, they just don't see fit to reach out to me even when I'm trying to reach out to them. But he has been maintaining communication. He's indicated that he wants to try and better his life. Because he's young, I'm hopeful that he'll have an opportunity to go forward and do some things that are meaningful with his life. And maybe now that he has a child, he'll see the benefit to maybe a good day's work in terms of see the responsibilities that he now has that maybe previously he wasn't thinking so closely about. I think that also distancing himself from maybe some other people who are causing him problems will be helpful to him. I have spoken to his mother, who has regularly contacted me, who does have good family support. I think that HIDA would be a good opportunity for him to ensure that he perfects his probation, and I guess to the extent that he doesn't successfully complete it, I guess the remedy is that he would conceivably lose that status and also be subject to jail. In some instances, Your Honor, I did tell the client this, that if the court were inclined to impose jail with the caveat that you receive the benefit of HIDA, there are many instances where the court will suspend the balance, but will hold the time in advance. And so if you violate your probation, the time is already imposed, for which you understood as well. He's just hopeful that he'll be able to get things straight. He's remorseful for what happened. And hopefully we don't see him again other than to just walk by him and say hello.
All right, thank you, Mr. Traxler. Anything that you wanted to say today?
Your Honor, I just want to go along with what they're saying. I just got into just a bad place in my life. I wasn't doing good. Right now, I have one child. He's one, and I have another on the way. Recently, I just actually got a job working at a restaurant just for some kind of money and to support my family. I'm trying my best. I'm just hopeful that you will think about HIDA and just give me a chance. Thank you, Your Honor.
Okay, I did read through the report, so I'm familiar with what happened in this particular case. There's also a lot of information in there about your background, your prior record and so forth. And it is concerning that at age 19, you're starting to amass a fairly substantial criminal history. And it involves a number of different theft crimes. There's an R&O in there. So I think you're running out of chances. You know, the argument that you're young and these are youthful mistakes starts to become weaker the more you continue to repeat the same behavior over and over again, because that shows that the age isn't really a factor. You're just engaging in criminal activity. I do think that there's really no loss to the community in giving you an opportunity under HIDA. It puts all the burden on you if you want the benefit of that to comply with your probation, and if you don't, it just gets revoked. So I don't see that there's any loss to giving you an opportunity. And I think, you know, you still are 19. You still have a chance to kind of put things together here and get on the right path. So I don't have an objection to HIDA, and the court is going to put you on probation pursuant to HIDA. In terms of jail time, though, I think you need to do some time here. You've already had a 60-day jail sentence. You've already had some time held in abeyance, 90 days held in abeyance on one of the retail fraud. Those things haven't been effective in terms of correcting your behavior. And I don't see any reason to sentence you to less in this case than you've been sentenced to on previous cases. I think the principle of progressive punishments, as you understand, the more you continue to do this, penalties go up, they don't go down, it doesn't go in reverse. So the court finds that jail time is appropriate in this case, and jail time in excess of what you've already been sentenced to on different cases in the past. So the court is going to place you on probation pursuant to HIDA for a period of 18 months. The court is going to adopt all the terms and conditions listed in the report. So it's important for you to go through those with your probation agent once you're released in order to make sure that you understand all the conditions of your probation. The guidelines in this case are 0 to 11. The court finds that a sentence in the middle of the guidelines is appropriate and accounts for your previous history as well as your behavior in this case. The court is going to sentence you to 6 months in the Kalkaska County Jail. You have credit for 43 days served. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a state cost of $68. You are also be required to pay a supervision fee while you're on probation of $30 per month. Mr. Ziegler, is there any restitution being requested?
Your Honor, the report indicates that probation reached out to the victim and he wasn't able to provide a number of restitution at this time. I would just ask the court permission to come back later with the restitution amount if we can get that number from the victim.
Okay, so the court will reserve restitution. The court will leave that to the prosecutor to file a motion for restitution if that becomes appropriate at some point. Because this is pursuant to HIDA, there are no appellate rights at this time. Mr. Ziegler, anything further we need to address here today?
There you are.
Mr. Seeger?
Thank you. Nothing further.
Can I just say one thing? Sorry.
That's up to you.
I know you've already made your option and everything, and there's no going back on that. I just want to thank you for this opportunity. I just want you to know that I have a baby coming. He'll be born before I get out. I'm really trying to change, man. In the 90 days and the 60 days, I got everything figured out. This is the only county that I have anything over me. I'm really trying to figure out my life, man. My girlfriend's down with me. She don't even know. I just want a chance. I understand this county has gave me a lot of chances. And I'm just trying to better my life. I don't want to go down this road. I don't want to be sitting in jail with my baby born. You know, it's heartbreaking. I've been through this so many times. Just asking the court if there's any way I could hold in advance or anything. I'm trying to clean up my life, man. I really am. I'm supposed to have a baby gender reveal. We didn't have that for my last kid. It means a lot. And it's just, you know, I got a job now. I'm gonna lose my job doing this. I'm supposed to start another job docking and making more money, you know, supporting my family. It just breaks my heart that I can't be there for my kid and my girlfriend. Like, I'm supposed to be a man, and I haven't been the man in the house, you know. I haven't, like, look at my record. I have, you know, it's a bum. Like, you can't get anywhere in life. It's not who I want to be. I grew up looking at my peers like that's not who I want to be. You know, like, I don't want to be like everyone that I grew up around in my life. I'm just asking, please.
Yeah, so everything that you're saying, I get it.
I understand.
And it stinks, but what you should be doing going forward is once you're done with this, the next time you're presented with the opportunity to engage in illegal conduct, you should think about this moment and think about everything that you're saying right now. And it should provide real motivation for you to not do it again.
I know, but
that's all. You're done. You're gonna go with the officer now.
Yeah. Yeah, it would have been helpful if you thought about that baby that was on the way before committing the crimes. Even if it was a split second before and it stopped you, then you'd be there for your baby. Then you wouldn't be facing losing your job. But you chose to go forward and commit the crimes. And it's sad, but that's on you. And hopefully the judge not bending and not giving in to his pleas and tears, hopefully that will remind him the next time and make it so there isn't a next time. Because it's possible to still have a future. He's real young. So he can turn this around. But he's the only one that can.
All right, sir, in Sheboygan there, can you tell me your name, please?
Jessica Matson.
Ms. Matson. Okay, Mr. Travis, are you ready on that file?
We are, Your Honor.
Okay, the court will call People versus Jessica Matson. This is case number 234880. The record should reflect Ms. Matson's appearing today by video from Sheboygan County Jail. If I could have counsel put your appearances on.
Brian Sigmund, on behalf of People, Your Honor.
Kyle Travis on behalf of Mrs. Matson.
This is set for show cause for failure to appear last month. And then a status conference here today. So Mr. Travis, how did you want to proceed?
Your Honor, in speaking with Ms. Matson a few days ago, I think she would like to accept the prosecutor's plea offer. It's my understanding that it's an alternative offer. Either she could plead to 1 count of possession of methamphetamine with no enhancements, or she could plead to 2 counts of possession of narcotics, the 4-year. It's my understanding Ms. Matson would like to accept the 2 counts of possession of narcotics, the 4-year. Relative to her, I don't know if the court wants to get into her non-appearance last month or not.
Yeah, please, if there's an explanation for it.
The situation was Ms. Matson has ties up in Sault Ste. Marie, and she had recently gotten out of jail, and she found herself up in Sault Ste. Marie without a phone or a car. Unfortunately, when she was starting to correct that, she ran into law enforcement a couple of days after our court hearing and was picked up on a warrant from Dutch Sheboygan.
Okay. So she was lodged essentially.
A couple of days after our court date. At the time of our court date, she was without an automobile or a phone, unfortunately.
Okay. All right. In terms of the plea offer, Mr. Ziegler, is that a correct statement?
It is, sir.
Okay. And as to the 2 possession charges, what's the substance that she's going to be pleading to?
Your Honor, I don't have a preference. The one that's charged is cocaine, so she could plead to 2 counts with a factual basis for cocaine, or she could plead to a possession of methamphetamine, and the court could take the 2nd possession of narcotics under the court rule.
Okay. And then if it's the 2 4-year, were there 2 different types of cocaine? Where did it occur on 2 different dates, or where do we get the 2 charges?
Your Honor, I think that the legal underpinnings or rationale behind it is that she's evading a 20-year alleged possession with intent to deliver methamphetamine.
Okay.
And so that's essentially being reduced to the possession of narcotics, and then she'd be pleading to count 2.
Okay, so take a factual basis to cocaine and to methamphetamine.
I think that would probably make the most sense.
Got it. Okay. All right, Ms. Matson, have you been able to hear all of that?
Yes.
And is that what you'd like to do, plead guilty to 2 4-year possession of narcotics crimes?
Yes, Your Honor.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Matson, were you on any probation or parole at the time that these crimes occurred?
Yeah.
You were, but was it probation or parole?
Probation.
Okay, so you understand that,
It was probation in Kansas, Montgomery County.
all right, so you understand that by pleading guilty here today, that could result in a violation of your probation there, and that you could get some extra penalties for that?
Yes, I do understand.
Okay, counsel, are either of you aware of any potential consecutive sentencing sanctions here? Mandatory?
None that are mandatory. Your Honor.
None mandatory from Your Honor. I must say I don't know how things work in Kansas, but
Okay. Not under Michigan law?
yes.
Okay. All right, and Ms. Mattson, you understand that by pleading guilty to each of these charges, that each of them carry a maximum possible penalty of up to 4 years and or a $25,000 fine?
Yes, sir.
With all of those things in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal this plea today or get it reversed, you would have to ask Court of Appeals, which is the next higher court up, to hear your case. They could say no, that would be the end of any appeal. Do you understand that?
Yes, I understand.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here on the record today?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty?
Yes.
The information I have indicates that this occurred back on July 3rd of 2023. Is that about the correct date?
Yes.
On that day, were you here in Kalkaska County?
Yes.
While you were here in Kalkaska County on that day, did you have possession of some methamphetamine?
I had possession of narcotics. Okay.
Okay, which narcotics did you have possession of?
Cocaine.
Did you have possession of any other drugs at that time?
Not that I'm aware of. From my papers, and I don't have all that paperwork with me.
All right, Mr. Ziegler or Mr. Travis,
Wait, you only would know if it was on the papers? Like, I'm sorry, but if I'm packing something, I'm pretty well aware of what I've got in my pockets. That's a bit confusing.
did you want to ask some additional questions?
Yes, so Ms. Mattson, you had illegal narcotics on you. Were there other groupings or other amounts of narcotics than just the cocaine in your possession?
Not that I'm aware of. No. I didn't see any of the evidence. I didn't see any evidence.
Ms. Mattson, this is about the evidence. This is about what was going on. If we want to accept the plea deal, we're not talking about the evidence. We're talking about what you know and what you're pleading to. So the question is, was there other narcotics there than just one batch of cocaine?
Yes.
Okay, and you're pleading to possessing two counts of narcotics, meaning there were two different batches of narcotics. Is that correct?
Yes.
Okay, thank you.
Mr. Ziegler.
Yeah, sorry.
I think we still need to establish what that narcotic was and whether she knew it was a controlled substance or not.
Okay, Mr. Travis.
So that other item, did you know that that was a narcotic?
Yes.
Me too, Salty Buddha, because my pocket's all wet then.
And you knew you didn't have a legal right to have it?
I didn't have a legal right to have it, no.
Okay, did you think it was methamphetamine? Did you think it was cocaine? Did you think it was heroin? Did you have any idea what you thought it was?
I thought it was meth.
Okay. Thank you.
I'm satisfied, right?
Okay. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor. Thank you.
All right, Ms. Mattson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Or these charges, the court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. Do you know how long you're gonna be in Sheboygan there?
I have not had court here for a while. It's going to be the 13th and 15th. And I also have a probation violation in Traverse City that I have to deal with. But I'm pretty sure it's gonna be a little while here.
She's just criming all over the place.
All right, so Mr. Ziegler, the court will ask that you prepare a writ for Ms. Mattson to be transported here to Kalkaska for sentencing.
Yes, Your Honor.
Mr. Travis, anything further that we need to address today?
Nothing further, thank you.
Ms. Mattson, do you have any
Oh,
questions?
Your Honor, I do apologize. Could Ms. Manson's bond be revoked?
Mr. Ziegler, any objection to that?
No, Your Honor.
Okay, if you can submit a stipulation in order with today's date, we'll sign that.
Oh, I just want to ask. if there's any
Okay.
or is it just-
It's 2 counts, so I had to count 3.
Okay, thank you.
Okay, thank you, Ms. Mattson. That's all for today. The court's gonna disconnect at this time.
I did have a question.
Sure, go ahead.
You guys, it's gonna be running a writ, right? So this is all gonna be running concurrent?
Right, your bond's being revoked, so you're gonna get credit and, yeah, I don't believe there's any consecutive sentencing sanctions here, so.
Okay,
If there are, you'd be advised of that and you would likely be given an opportunity to withdraw your plea.
okay. That's all I had to
Okay.
ask.
All right, sounds good. Thank you. Thank you. And do you have Mr. McGuire here?
Your Honor, I don't see him in the courtroom. I don't see him out on the hallway. I will go look around and give him a call.
Okay, we'll call that case in a little bit. Take a short recess and come back on the record in about 5 minutes. The court will call People versus Elijah Aguero. This is case number 234860. Executive counsel put this here.
Ryan Ziegler on behalf of the people, Your Honor.
Good morning, Your Honor. Marie Vandenberg on behalf of the Socorro.
Mr. Aguero, I'm gonna have you go right to the podium there, around the back. Record should reflect Mr. Aguero is present here in the courtroom today. I did receive a number of character letters on behalf of Mr. Aguero this morning. I had a chance to review those prior to the hearing today, so both counsels aware. And Mr. Aguero, have you had a chance to go through the pre-sentence report and talk to Ms. Vandenberg about that? Ms. Vandenberg, are there any additions, deletions, or corrections that need to be made to that report?
Your Honor, I spoke, yes, there is, Your Honor. I spoke with the prosecutor as well with regard to the scoring. So our challenge is to the scoring of OB3 at 25 points. We believe that should be 0.
Okay, hold on 1 second. Are you objecting to the change in scoring?
I'm actually not, Your Honor.
Oh,
It's
okay.
improperly scored.
Okay, so OB3 is scored at 25, and what should it be scored at?
0.
And Ms. Vandenberg, that's what you're asking?
That is what I'm asking, Your Honor.
All right, so that's a significant reduction in the OB score. That leaves us with 15 then, and where does that leave us with the guidelines?
We believe the guidelines to be 0 to 17. 17 minutes.
I agree, Your Honor.
0 to 17, okay. And so the court will order that those changes be made to the SIR to reflect a 0 to 17 guideline range. Any other changes, Ms. Vandenberg?
No other challenges, yeah.
Okay, are there any additions, deletions, or corrections to the report itself?
There aren't any, no.
Oh, Mr. Ziegler, do the people have any additions, deletions, or corrections?
Your Honor, on page 3, there's 2 lines of victim impact statement at the bottom of the page. It says writers. Brandon, she and the defendant are parents of Joel. I believe that should read deceived. Parents of Joel.
Okay. Any objection to that change, Ms. Vandenberg?
No objection, no.
Okay. Any other corrections?
No, Your Honor.
Do people have any challenges to the guidelines?
Other than the change that's already been reflected, no, Your Honor.
Do you have any victims that wish to address the court today?
I do, Your Honor. Miranda Brandon would like to address the court.
Okay, so Mr. Guerrero, if you can have a seat next to your attorney there, please. Ms. Brandon, if you'd like to come forward.
Y'all get your tissues out. The fact pattern of this hearing and the impact that it had on the people, it sucks. It sucks.
And can you just state your name for the record?
My name is Miranda Brandon.
And what's your relationship to
It's
this?
in my letter.
Okay, but can you just tell me for the record?
We are co-parents and best friends.
Thank you. Please proceed.
To whom it may concern, I am Miranda Brandon. I've known Richard Jeffers, the victim, for almost 20 years. We were best friends and co-parents of 3 beautiful children of 14, 12, who found the victim, and 8. 2 of my kids' birthdays were 2 months after the incident, and Christmas was 6 months after. If it wasn't for my children's school, they wouldn't have had Christmas. But it's not just about birthdays or the Christmases. It's about all the other important dates in their life, like graduation, marriages, and grandbabies. There's not a sentence long enough to bring back the kind, loving, caring person that we have lost. Thank you.
Thank you. Any other victims, Mr. Ziegler?
I don't believe so.
Okay. Anything on behalf of the people, Mr. Ziegler?
Your Honor, this is a case where the defendant delivered controlled substances to Richard Jeffers, which caused his death. The investigation revealed that the defendant, Elijah Aguero, had been very active in dealing controlled substances, both in this community as well as other areas. Specifically, it showed that the victim and the defendant had had a conversation shortly before the victim's death, where the victim was looking to obtain some boy, which is drug slang for heroin. The victim later died, and blood testing showed that he died of fentanyl toxicity. The court is likely all too familiar with these facts, as fentanyl has become something of an epidemic in our community. And it seems like every time there's a delivery causing death case, it's a case where the victim believed they were buying heroin, but instead took fentanyl and died due to that substance's severe toxicity. On the positive side, in this case, Your Honor, the defendant's a young man. He has time to reform his life. He has no prior record, and he did not intend to kill anyone. However, on the negative side, he is clearly a serial drug dealer. He has other pending charges for delivery. I believe that's out of Benzie. He either knew the substance he delivered was fentanyl, or at the very least, he did not know or care whether the substance was heroin or fentanyl. His behavior has caused the death of at least one person. He is richly deserving of punishment in this case, Your Honor. Unfortunately for all of us, his guidelines in this case are somewhat low, in my opinion. He has no PRVs. He has very few OVs. While the plea agreement did not call for a sentencing cap, it did call for the prosecution to recommend a sentence within the guidelines range. While the guidelines are low for the severity of the offense, I do believe they take into account most, if not all, of the relevant sentencing factors, as OV3 specifically instructs the court not to score for the death of the individual. And his other drug dealings do not relate to the sentencing offense, except as to show his mental state. Since the guidelines are presumptively reasonable, Your Honor, I would recommend a sentence within the guidelines. And since the crime resulted in the death of the victim, and since the crime was the result of an intentional course of conduct by the defendant involving distribution to many persons, I would ask the court to sentence the defendant to the highest possible sentence within those guidelines.
So what happened was this young man was dealing and his batch was laced. He sold it to another man and that person passed away because he expected he was getting one thing and he got another. So now, the defense is arguing that, well, he doesn't have a prior record and he's a good little boy. You should go easy on him. But he wasn't a good little boy. This is just the first time he got caught. And he didn't get caught because he got arrested, got pulled over and they found it in his trunk. No, he got caught because his stuff was laced and someone passed away because of it. He's lucky that he's not being charged with a much more serious offense.
Thank you. Thank you. Ms. Vandenberg, if you and your client would like to come back to the podium.
Yes, John.
And Ms. Vandenberg, anything you'd like to say on behalf of your client today?
Yes, thank you, Your Honor. Your Honor, Mr. Aguero is a young man. He was 17 years old at the time of this incident. He's now 18. He's been incarcerated in the Antrim County Jail for about 170 days. So he has had a lot of time to reflect on the behavior that brought him before this court. He has had a lot of time to think about his future, the fact that he was on a wrong course. And when I say that, on a wrong path, this young man has a very loving, caring family. His mother is in the courtroom, his mother's fiance, and his two siblings are in the courtroom. As the court stated on the record, the court has reviewed 5 letters in support of Mr. Aguero. And the letters, they all have one common theme, and that is this is a kind young man, caring young man, a very helpful young man to his family, to his grandparents who wanted to be here but were unable to due to their health. He has a community of people that love him, that cherish him, that want to see him do better. And I've had many conversations with Mr. Aguero, and one of the things, Mr. Aguero, that struck me is the fact that he's remorseful, he's sorry. He didn't mean for any of this to happen. And he appears to be a serial, or at that time, a serial deliverer of drugs, but that wasn't the case. I think he was influenced by people that he should not have been around. When he is released from incarceration, I believe that this young man will be a law-abiding citizen. And it's not, I don't say it lightly, Your Honor, I don't, and I know the court has heard it all, but he has such a bright future. He plans to go back to school, get his GED, he plans to then advance education. He aspires to own his own business, to help his mother with his siblings. His mother lives in Waterford. He needs to get out of the community that he was in prior to being incarcerated. And I'm not blaming anyone but him. And he's taken full responsibility. He feels so horrible what happened to this family, and he apologizes. I just don't, he's not a bad person. And I think given the amount of time that he has been incarcerated, he has had opportunity to think about what he's done And to say to himself and to his family, to this court, that he will never be before another court on a felony matter. And he said never. And I said to him, what are your plans? What are you gonna do? How are you gonna keep yourself out of trouble? Get out of the community, get out of Muskegon.
He was 17 at the time of the offense, and he's now 18. He threw his life away. And I'm sorry, this argument of he's not a bad person. Lady, he unalived someone. Yeah, that person made the choice to take that product in the first place. So they had a hand in their own unaliving. But if there wasn't access to it, if it wasn't being sold, if he wasn't the hand that passed it along, if you can't get your hands on it, you can't do it. He did this. I don't care how good of a person you think he is. That person's family, that victim's family, they can never have their dad, their co-parent, their son, their brother back. It's tragic.
I mean, there's drugs everywhere, but there's an abundance of drugs. There's abundance of gangs in that area. And this young man just doesn't need to be a part of any of that. And he can live with his mother. His mother has said he's more than welcome to come home to her and to his siblings. And that's what he's planning to do. And Your Honor, I don't, a person died, and that's a horrible thing. A life was cut short. A life that someone loved. He had children, children, a significant other, people who loved her. And Mr. Aguero doesn't take that lightly. He is truly remorseful, and he'll speak to that remorse and how he feels and what his plans are. And he's just asking the court to sentence within the guidelines. I would ask for a county cap, and I know that sounds horrible, given that a person died, but I believe that this man deserves another chance.
My apologies. I didn't realize the victim was a female. I got that part wrong.
And I'm asking the court for that opportunity for Mr. Aguero and for his family. Thank you.
All right, thank you. Mr. Aguero, anything you wanted to say today?
Yes, Your Honor. I would like to read this letter. I wrote a letter to the court. I referred to the family, sincerely send my condolences for this hard time they are going through. They have been in my prayers. I just wanted to say that I'm not a statistic. I have aspirations to become a young, successful entrepreneur and going to college to get a degree in business. My mother is willing to allow me to move with her in Waterford, Michigan, to help me progress towards my goals. I was raised by a hardworking Christian family that just wants the best for me. I just asked the courts to give me one opportunity to show you guys that I truly have aspirations and goals I plan on accomplishing.
All right, thank you. I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your background and your circumstances based on that information in that report. As I indicated, I also did read through the letters that were provided on your behalf. Ms. Brandon, I also want to thank you for making a statement this morning. I appreciate what you had to say. Obviously, that has an impact on the court as well, along with all the other information. Along with what both the lawyers had to say. And obviously, this is a very tragic circumstance. And whether you intended the death to occur or not, you certainly intended to sell the drugs to this person. And fentanyl is an incredibly dangerous substance. It frequently results in overdoses. Part of the problem is people don't know what they're getting, and maybe you don't know what you're selling. And they're taking the substance voluntarily, and you're certainly selling it voluntarily. And I agree with what Mr. Ziegler said. Either you don't know what's in it, or you just don't care because you want to make some money and accomplish your own ends. You don't really, at the time, care what happens to the people who get the drugs that you're selling to them. And unfortunately, frequently they do have deadly levels of other substances in them. And when that happens, you bear the responsibility for that because you're the one who engaged in that conduct. And some mistakes carry with them heavier consequences than others. And this is that kind of mistake. I am satisfied based on the information in the report that this wasn't like a one-time sale. You were actively engaged in selling drugs in this community. And so you're voluntarily accepting the consequences that come with that activity. You didn't have to do that. That's a choice that you made. You could have chosen to stop doing that at any time, and you chose to continue to engage in that conduct. And it resulted in the death of another person. So I think there is a consequence that has to be paid for that. Your age, your lack of any serious prior criminal history limits the consequences that you're going to pay. And what that means is that you're going to have an opportunity in a relatively short period of time to seek out those opportunities that you indicated and that your family indicated in their letters that you want to pursue. So you know, you're going to pay some consequences here, but you have an opportunity to move forward from this, and it'll be up to you as to whether or not you actually do get away from those bad influences, whether you do actually make some better decisions going forward. All that's going to be on you, and time's going to tell. And I hope that's the direction that you take things, because you are a young man and you do have a lot of time to go in the right direction, regardless of the wrong direction that you've chosen to go into as of now. All of that being said, I do think that a sentence at the high end of the guidelines is appropriate. I think it's necessary to impose a degree of punishment on you, some consequences to you, and also as a deterrent effect, so that you understand that if you continue to engage in this conduct in the future, the penalties are only going to get more severe from here. The court is going to sentence you to 17 months to 15 years in the Michigan Department of Corrections. You do have credit for 170 days served. The court is going to order that you pay a crime victims assessment in the amount of $130, court costs of $325, the DNA testing fee of $60, and state costs. You do have the ability to seek an appeal of this sentence. Ms. Hindenburg, the officer is going to provide you with your appellate rights. You can have him initial those.
17 months to 15 years. That is a very wide open time span. That kid's gonna have a lot of time to be thinking about it. He's gonna have to just keep going in front of the parole board over and over until he's released. And this will follow him. Like I said, he threw his life away. And another person's.
Let me know once he's acknowledged.
Yes, no. Mr. Burrell has signed a notice of right to withhold.
Mr. Ziegler, is there anything else that we need to address?
Nothing further, Your Honor.
Mr. Aguirre, you are remanded to the custody of the state at this time. Okay, we're on the record now in People versus Broker. This is case number 224705. The record should reflect Mr. Broker is present today by video from Wexford County Jail. If I could have council put your appearances on.
Brian Ziegler, on behalf of the people, Your Honor.
Thomas Seeger agreeing with an behalf of Mr. Broker.
Okay, Mr. Seeger, this is your motion. I don't know if the parties have received this. I'm in receipt of a recent evaluation dated February 27th, 2024. That's in the file.
I'm not sure I received that correspondence, John. If there was correspondence, I'm not sure I received it.
I received it this morning, Your Honor.
All
I
right.
just had an opportunity to read through it.
Looks like it was just filed with the court yesterday. It's dated February 27th, and it relates to the most recent evaluation. It looks like the Forensic Institute had Forensic Center had an interview with Mr. Broker on February 27th. And their opinion as of February 27th is that he remains incompetent. I don't know if that affects your motion today or not.
Well, Your Honor, I guess it really doesn't particularly affect my motion per se, Your Honor. I am familiar with the court rule, and I did discuss it with Mr. Ziegler, but I guess my larger concern is, that at least it's been my experience in the past, wherein somebody has been determined to be incompetent, that they essentially will take them to the forensic center and they will attempt to restore them to competency. And so the only service, at least as far as I'm aware of, that they provided to him is none. Like they may have reevaluated him, but ordinarily they'll attempt to restore you to competency, where you'll do some classes, they'll ask you questions, etc. For which they've not afforded him any of those opportunities to attempt to restore him to competency. So I don't know what it is that they specifically did. But I guess because there's been so much time that has passed, I'm just a little bit concerned that he's not able to post his bond, despite their findings that he's not competent at this time. And speaking with Mr. Broker, he had indicated that he wished to proceed to trial, which I can't do while he's currently determined to be incompetent. There was an offer that was extended to him at one point in time where he could plead to an attempt, together with a domestic violence charge, for which he's denying is untrue. And again, he wishes to proceed to trial, but I'm just at a little bit of loss because he just can't let this case linger without the forensic center doing something. If he continues to be incompetent in perpetuity, then I guess we'll have to look at some other remedy, but I guess just so much time had passed, Your Honor, where he's not been able to post his bond, I felt like I needed to at least let the court know that I didn't feel as though the forensic center was doing what I felt they needed to do, and there was an order wherein he was determined to be incompetent, so I felt as though he should be taken there for further work, yes.
All right, Mr. Ziegler.
Your Honor, I assume the court has read my motion. Largely, I would rely upon that. I don't think there's any court rule that allows for the relief that the defense is requesting. That specifically, that rule denies that relief. Similarly, the statute denies that relief. I would also note, just as new information, Your Honor, I believe it was yesterday, Mr. Soller we had a competency status hearing on him, and he was recently transported to the forensic center. He's been in our custody for a lengthy period of time, I want to say several months. And he was recently transported to the forensic center. So it's not like the forensic center is just wholly abandoning this county or has forgotten about this county. I believe they legitimately are lacking beds to deal with the volume of people that are in need of treatment. I would also note, and although I understand Mr. Seeger has not received this, but in terms of the report that we received, Mr. Broker appears to still be under some delusions and some concerning behaviors, at least as of February 27th, as detailed in that report. So in terms of my arguments relating to his release, if the court, for whatever reason, decides he is released, this is just further evidence that at the very least the petition needs to be filed related to voluntary hospitalization prior to his release. So other than that, Your Honor, I rely on my motion.
Okay, I think the law is pretty clear that the court can't grant a PR bond for the reasons stated. And that being that the forensic center has not engaged in any treatment of Mr. Broker in an attempt to return him to competency. So the court's going to deny any kind of bond for that reason. However, I totally agree with you. I think the forensic center is finding that he's incompetent but could be restored, then he needs to be transferred to the forensic center for treatment to determine whether or not he can be restored. So This isn't really a legal remedy, but the court is going to make written inquiry to the forensic center about the status of his case, when we can expect him to be transported there for treatment. I'll copy counsel on that in the file as well, so there's a record. The court's made that inquiry. We'll see what the forensic center says, and we'll go from there. But I think inquiries, I think Mr. Seeger's point that he needs treatment is correct, and I think inquiries at this point need to be made as to why that hasn't occurred yet. So
Yeah.
The court will do that before the end of the week, and again, counsel will get copies of that letter as well as any response from the forensic center.
Thank you.
Okay. Thank you. That's all for the court's morning docket. The court will be in recess until 1:30.
Well, guess what, guys? Unfortunately, that's all I have. I would have more, but you know, I deleted my editing and I'm a little salty about that. Just a little bit. Did you get him, Tammy? Did you get Mortimer Duke? Thank you so much. Oh, you didn't. I know you. I knew what you were doing. I knew it. I knew exactly what you were doing. Who'd you get? The Ava stream. Ava's outside. I put her out to go potty when I got my coffee, and I haven't gone back out to get her yet. So no, unless I just leave you here. Yeah, it's 1:30 in the morning. July, 2021, I wouldn't have it. I wouldn't have it that far back, but I'm familiar with courtroom archives, so all right, guys. I'm gonna go get my puppers and then get some sleep maybe tonight. I have not. Oh, for real? Are you for real, Becky D? Oh my gosh. Okay. All right. But I got to put something on. I can't just leave it dead air, you staring at my BiPAP machine and empty bed. I mean, that's just depressing. For me, mostly. Okay. Let me see. Oh, you know what? All right, give me a second here. My mouse, I got a notification on my computer that said my mouse was at 4% battery. I didn't know that it did that. That was great. I was really happy that it told me. All right, here we go. Fresh from 9 hours ago. And now Can you guys hear?
Having some technical difficulties. Let's see. All right. Good afternoon, everyone. Are you able to see and hear me?
Yes, ma'am.
Yes, all right. Wonderful. This is the state expedited accusations calendar in the state court of Fulton County, Georgia. I am Judge Melanie Williams. At today's calendar, we will set bonds in misdemeanor cases that have been already formally accused by the Solicitor General and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney. As you can see, I'm conducting this hearing over the internet. It's being live streamed and recorded. That means any member of the public can log on and watch today. When I ask if you understand your rights, that is what I am referring to. Ms. Bridgewater, what is my reset date?
It is March the 19th.
All right. Those who receive a signature bond will be reset for the notice. Those who receive a surety bond, whether through pretrial or those who receive a surety bond or a cash bond will be reset to the state all-purpose calendar as Ms. Bridgewater just indicated. All right, have all defense attorneys had the opportunity to interview their clients?
Your Honor, I would like to interview my client, Mr. Luis Morales Navas, with Spanish interpreter at the breakout room.
Okay, understood. That's appropriate, Ms. Kim. Is that party at a separate courtroom or will they be taking over?
They're going to get him now, so they'll be taking him to courtroom 1. They'll log on in courtroom 1.
Okay, so whenever courtroom 1 logs in, if we could put Ms. Chancey and Ms. Kim into a breakout with that courtroom. Ms. Chancey, please
Yes,
state your
ma'am.
name for the record.
Yes, good afternoon, Your Honor. My name is Adriana Chancey, Chancey.
All right, thank you, Ms. Chancey. Please raise your right hand. Do you swear and affirm that today you will make an accurate translation from English to Spanish, Spanish to English to the best of your skills, knowledge, and ability?
Yes, I do, Your Honor.
All right, you can put your hand down and you will remain under oath for the duration of this proceeding.
Thank you, Your Honor.
All right, who do we have first at courtroom 2?
Position number 5, Colquitt.
All right, give me one moment. All right, 29. All right, good afternoon. Oh, my phone is now doing something. Okay. All right, good afternoon, Ms. Colquitt. Your case is 24 CR 001044C. You are charged with simple battery. Do you understand your rights today?
Yes, ma'am.
All right, I have that this is first arrest, so we'll go straight to Mr. Pierre Thomas.
Your Honor, good afternoon, Your Honor. The brief facts of this case is that on looks like March 5th, 2024, the officers met with the victim at the Marco's Pizza located at 5075 Abbott Bridge Road. He stated that the offender was his ex-girlfriend and that she walked in and confronted him about cheating, that he tried to de-escalate the situation by walking into the restroom and trying to separate himself from her. She followed him and grabbed onto his shirt and repeatedly punched him in the back. She then ripped the shirt off and started to punch him in the chest. 2 witnesses confirmed the events that were described in the warrant by the victim. The owner of the business arrived on scene and showed the surveillance footage of the incident. In the video, you can see one was also which also confirmed the events that were in the warrant. I guess the victim was asked if they ever lived together and if they were dating in the past, and the victim confirmed. Our office unfortunately has not been able to get in contact with the victim. The victim's name in this case is Tyler, Tyler Morez. Also, if we could sound for him in accordance with Marcy's law, that'd be greatly appreciated. But the request from the state is a signature bond to the pretrial services, no alcohol, drugs, or weapons, and no further contact, and the stay away from the incident location, and the completion of an anger awareness course. Nothing further to add from the state at this time.
Okay, is Tyler Morez present on the Zoom conference and wishes to make a statement? Okay, I don't see anyone on the screen with that name. All right, Mr. Cook?
Yes, Your Honor. Given the situation, given the client's background, we would be seeking signature only bond through the jail. She wants no further contact, and she has no problem with the stay away from the specific incident location. Now, they both work at Marco's, but she can work at another location several miles away. So we would like her to be able and scheduled in such a way that she would never be in contact with the alleged victim. So we would like for her to have that option. Obviously, if the manager chooses to terminate her, that's the manager's prerogative. I always see no reason at this point for anger management.
Okay, back up. I'm sorry, Mr. Cook. She still works at that incident location?
No, it's Marcos is a chain. She can work at another Marcos. She has no problem staying away from that specific Marcos.
Okay.
Wanted to cover the one several miles north of there and coming. This one was in Loretta.
Okay, so if I do the stay away, she can keep her job. Okay, defendant is gonna receive a $7,500 signature bond through the jail. She's to have no contact with the alleged victim in this case. Stay away from that location, that specific Marco's Pizza. Additionally, she's to have no drugs, no alcohol, and no weapons as a condition of that signature bond through the jail. Is there anything additional?
Nothing else, Your Honor.
All right, best of luck to you. That concludes your case. Who do we have next?
I'm sorry, position number 6.
Okay. All right, good afternoon. Are you Alexandria Darboz? Please pronounce your last name for me.
You pronounce it right.
All right, Ms. Darboz, your case is 24 CR 001045A. You're charged with battery, driving while your license was suspended or revoked, and disorderly conduct. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
For a total 2023 suspended license, 2023 shoplifting.
All right, Mr. Graham, please proceed.
Thank you. Good afternoon, Your Honor. This incident took place on March 4th, 2024, at a gas station Big 4 Food Mart at 1003 McDaniel Street in Atlanta. Ms. Alexandra Darboz approached her ex-boyfriend at that location. His name is Dante, D-A-N-T-E, Rivera, R-I-V-E-R-A. She began striking him, threw several items and sodas at him, and tried to block his vehicle so he could not leave the location. They eventually both left in separate vehicles. Eventually, she parked the car and she began striking both cars with a metal pole. Our office has been unable to contact Mr. Rivera, and it seems that he was also arrested on a driving with suspended license charge. And the state is requesting on the battery a $2,000 good bond, and on the driving suspended license and disorderly conduct, $500 signature bond through pretrial services each. No further contact with Dante Rivera. Stay away from that Big 4 Food Mart location. No alcohol, drugs, or weapons while out on bond.
Okay. Is Mr. Rivera present and wishes to make a statement? Okay, I don't see anyone with that name. So we'll go to Mr. Cook.
Your Honor, my client is 25 years old. She has a degree in early childhood education from Albany State. She works in that field. Given her background and given lack of previous record of any substance, she can stay away from the incident location. She's more than happy to stay away from the alleged victim. We would be asking for a signature only bond through pretrial.
All right. Defendant is going to receive a $6,000 signature bond through pretrial services. It'll be 4,000, she has three charges, 4,000 on the battery and 1,000 each on the remaining charges. She is to take the 1-day anger awareness course. She's to have no contact with the alleged victim, and she's to stay away from that Food Mart location. Additionally, she's to have no drugs, no alcohol, and no weapons as a condition. Is there anything additional? All right.
Nothing
Best of,
else. This one.
best of luck to you, Mr. Arbose. That concludes your case. Who do we have next?
Number 9, Ms. Green.
All right, Ms. Green, good afternoon. Your case is 24 CR 001052B. You're charged with simple battery family violence. Do you understand your rights? All right, Mr. Howard.
Fifth arrest. I got a 2017 FTA, and that's pretty much it.
That's all? Okay. Mr. Graham?
Thanks, Your Honor. This incident took place March 4th, 2024. Law enforcement was dispatched to 3038 North Street in East Point regarding a fight. Upon arrival, the officer spoke with Mariah Green, Greene, who stated that she was in a physical altercation with her roommate, Katasha Green. Ms. Mariah Green explained that she was lying in her bed when the defendant came to her room to confront her about leaving clothes in the dryer. She stated that she would remove the clothes, but they began arguing about some other things. At that point, the defendant charged at her with her hands, grabbed her by the hair, and began pulling her hair. That started a physical altercation that occurred, and after they separated, she was able to call 911. Our office has been in contact with Ms. Mariah Green, who stated that the defendant is a family friend. She was allowing her to stay with her, that she's been staying there for a few weeks now, that the incident location is the victim's residence. She confirmed the events in the warrant, that she's going to file for a TPO. She wants no contact with the defendant, wants her to stay away from the residence, and stated that a relative of the defendant is coming to pick up the belongings. She did indicate she'll be on Zoom, so if we can sound from Ms. Mariah Green. The state is recommending a $2,000 signature bond through pretrial services, no further contact with Mariah Green, stay away from 3038 North Street in East Point, anger awareness course, no alcohol, drugs, or weapons while out on bond.
Okay. I did see Ms. Green. If you wish to make a statement, Ms. Green, I need you to turn on your camera and raise your right hand. However, you are not required to make a statement at this time.
Okay.
Do you wish to make a statement? All right. You raise your right hand, please swear. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Before you begin talking, today, what I'm most concerned with are any concerns you have for your safety and your thoughts about desire for contact with the defendant. If you disagree with something that Mr. Graham stated, that's not what's of critical importance to me. Today is a bond hearing, and as this is a misdemeanor offense, she is entitled to a bond today. So again, with those instructions, what would you like to tell me?
I just wanted to be clear that the fight did not start over laundry. It started over like something totally different. When I was in my room, she called me saying that there's laundry in the dryer, and I took it out, and that wasn't an issue. And then afterwards, she brought up some outside issues that had nothing to do with me.
Okay, so concerns for your safety and desires for contact. That's what I'm interested in.
Yes.
Yes, please explain. You are concerned for your safety, or
I am concerned. I'm concerned for my safety, and I desire no contact.
Okay, thank you so much. I appreciate you coming to court making that statement. All right, Mr. Cook, please proceed.
Your Honor, we have no problem with a no further contact or stay away from the incident location. We will be asking for a signature only bond and at least have the option of a one-time law enforcement officer visit, so she can determine what belongings she may still have there and be able to remove.
All right. Let me review the number. She just has the one charge, correct? Defendant is gonna receive a $4,000 signature bond through pretrial services. She is to take the 1-day anger awareness course. She's to have absolutely no contact with the alleged victim, whether through text, email, social media, no contact whatsoever. She is to stay away from the location on North Street. However, she can return one time with a member of law enforcement to get any of her items that may still be there. Additionally, she's to have no drugs, no alcohol, and no weapons as a condition of that signature bond for pretrial. Is there anything additional?
Looking from the defense, Your Honor.
All right. But best of luck to you, ma'am. That concludes your case.
Position number 11.
All right. Is it Gidon? Pronounce your last name for me.
It's Gilden.
All right, Ms. Gilden, your case is 24 CR 00105-3Y. In this case, you're charged with disorderly conduct. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
For a total 2021 DUI conviction, 2016 shoplifting, and a 2014 simple battery dismissed.
Okay, thank you. Mr. Graham?
Thank you, Your Honor. This incident took place March 5th, 2024. Law enforcement responded to a disturbance call at the Economy Hotel located 9995 Old Dogwood Road in Roswell. Upon arrival, the officer spoke with the caller, Jane Mayer, M-A-Y-E-R, who advised that Bobby Gilden had been pounding on the doors of various rooms, stating that someone had stolen her money and her purse. She then was involved in the fight with someone who had pulled up at the hotel. The officer observed security footage showing Ms. Gilden banging on several doors, speaking with one of the tenants there. Several witnesses corroborate the account of the caller. One witness said he heard gunshots, but no gun was found on the scene or on Ms. Gilden's person. And Your Honor, the state is recommending a signature bond through pretrial services, an anger awareness course, stay away from the Economy Hotel, and no alcohol, drugs, or weapons.
All right, thank you. Ms. Atai?
Yes, Your Honor. My client is 27 years old. She has lived in Georgia all her life. She is gainfully employed as a bartender at Red Lobster for the last 2 years. Your Honor, she has no violent history. She is a high school graduate, studied at Georgia State University. She does suffer from a severe immune system disorder. I would ask for a signature bond through the jail. This is a disorderly conduct charge. And she did say that she did knock on a door to get money that, from someone who she said had taken money from her while she was distracted. But she does deny that there was, denies the allegations in the warrant. And I would object to a stay away. She states that this is this Economy Hotel is where she's been living. It's right by her place of employment, and it's the only place that she can afford to stay in that area and keep her job.
So she has a severe immune system disorder and she's out there fighting with people. If somebody stole your money, you call cops and let them deal with it. And then you don't have charges. And then you don't have to go to jail and worry how you're going to get your medical treatment.
Okay.
Think further.
All right. Defendant's going to receive a $2,000 signature bond through pretrial services level 1. I will not require the stay away. I will not require the anger awareness. Additionally, she is to have no drugs, no alcohol, or weapons as a condition. Is there anything additional?
Nothing further from defense. Thank you, Your Honor.
All right. Best of luck to you. Who do we have next?
Position number 12 is next.
Okay. Uh-oh. Okay, 12. This is Jaleesa Henderson. All right, your case is 24 CR 001054B. In this case, you're charged with battery. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
16 total. 2023 FTA, theft of services, probation. 2021 probation, 2020 violation of family violence order conviction, 2019 battery DV conviction, 2018 theft of services conviction, and a hold out of Cobb. This Henderson, right?
Yes.
Yeah. Okay.
Okay, thank you. Mr. Graham?
Thank you, Your Honor. And I would like to announce that the accusation has been amended to battery family violence. She and the victim live together at the location. This incident took place on March 4th, 2024. Law enforcement responded to a fight call at 2532 Jewel Street in East Point. Upon arrival, they observed both Miss Jaleesa Henderson and Miss Stephanie Redding in the kitchen of the residence yelling at each other. Miss Henderson had a strong odor of alcoholic beverage coming from her person, and the officer did observe an open bottle of alcohol in her room while he was speaking with her. Miss Redding advised that she was in the kitchen when Miss Henderson started being belligerent and yelling at her. Miss Henderson then charged at her, grabbed her, and started shaking her aggressively, and that's when the physical fight began. The officer did notice swelling to Miss Redding's left eye and her right wrist. Our office has been in contact with Miss Redding. She states that she and Miss Henderson are roommates at the incident location. It's a house where they each rent a room. She stated that Miss Henderson does have some alcohol issues, that she's been aggressive towards her and her children, but this is the first time she's been violent. She's okay with the defendant returning to the residence as long as she's not violent. She indicated she'll be on Zoom if we can sound for the victim. And Your Honor, the state is requesting signature bond through pretrial services, ADET. We are still going to ask for no further contact with Stephanie Redding at this time. Stay away from the incident location. No alcohol, drugs, or weapons.
All right, is Ms. Redding present on the Zoom conference and wishes to make a statement? If so,
Yes,
please turn the camera, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Same instructions as I given previously. This is a misdemeanor offense, so the defendant is entitled to a bond, and I'm not sentencing her today. What I'm concerned with at this time is your desires for contact or any concerns you have for your safety. If you disagree with the facts, that's not of primary importance. So what would you like to tell me?
I would like for you to know that I would like the young lady to get some sort of help. She needs help with her drinking. It becomes a serious poison in her body. She becomes very, very, very angry. Most of the time when I do see her at the house, she's in that same state, extremely drunk, very loud, always starting an argument. But the arguments always involve me, my boyfriend, and my children. And I would like for her to get a grasp of that so that I don't mind her returning because I don't want to make her homeless, but I don't want her coming back and discussing my personal life from her view with anybody that's not asked her. I don't want her talking to me or my children. I don't want her talking to anybody about me, my children, nor my relationship or my man.
As the lady in the stalking case so eloquently put it, keep my name out your mouth.
To stay away from our door. Do not knock on our door. Don't knock on the door for us to let her in the house when she's drunk at 2 a.m, 10 at night. Just leave us alone, please.
All right, thank you. Mrs. Ty?
Yes, Your Honor, my client is 32 years old. She has lived in Georgia for over 10 years. She does deny the allegations and states that she's the one who called the police. The complaining witness can let us know if that's, if she's not the one who called the police, she stated that she was transported to Grady where they found a knot on her head and she was diagnosed with possibly a concussion. I do see several large bruises on her, Your Honor. She does work as a restaurant, as a server in a restaurant that recently closed, but she is going to start another job at a restaurant in a week. I don't have an objection to the signature bond through pretrial services. The complaining witness has stated that she's fine with her returning to the home and she doesn't want her to be homeless. And of course, I would object to a stay away. No violent contact. I'm asking for no violent contact, and I do object to the ADET. I think it's not really appropriate at this point.
All right, defendant is gonna receive a $5,000 signature bond through pretrial services level 1. She's gonna take the 1-day anger awareness course. She's to have no further violent contact with the alleged victim. However, I am instructing her to avoid and stay away from this young lady. It's in your best interest, ma'am, if you see her, to turn around and go in the other direction and to have no contact. Additionally, I'm not going to require the stay away at this time, but she's absolutely to have no alcohol, no drugs, and no weapons. Mr. Howard, can she be subject to random screens if I send it through pretrial?
Sure.
Yes, and she'll be subject to random screens. All right, best of luck to you, ma'am. That concludes your case. Who do we have next?
Position number 13, Mr. Lott. Come on, ma'am.
All right, good afternoon, Mr. Lott. Your case is 24 CR 001055H. In this case, you're charged with simple battery, family violence, and criminal trespass. You understand your rights?
Yes, ma'am.
All right.
What's his name?
Lott 13.
First, jail's the recommendation.
Okay. Mr. Graham?
Thanks, Your Honor. This incident took place on January 3rd of 2023. Law enforcement responded to a disturbance call at 3599 MLK Junior Drive, Southwest Atlanta. Upon arrival, they spoke with Lamaya, Lamaiyah Banks, who advised that her ex-boyfriend Malik Lott punched her in the right shoulder several times and took her cell phone. He threw the cell phone on the ground, shattering the back and front sides of the phone. Our office has been in contact with Miss Banks. She states that they are currently in a relationship. They do live together. They share one child, and that she is currently pregnant with their second child. She states that the incident was a big misunderstanding. She denies some of the facts in she denies that Mr. Lott hit her. She did confirm that he did shatter the phone on that date. She does not want to press charges. This has never happened before. Nothing has happened since that they've been living together since the incident without any further issues. She does want contact with the defendant. If we can sound for Ms. Banks, in accordance with Marcy's law, the state is requesting a signature bond through pretrial services, still a 1-day anger awareness course, no further violent contact with Lamaya Banks, no alcohol, drugs, or weapons while out on bond.
All right, is Ms. Banks present and wishes to make a statement? No, Ms. Banks? I don't see anyone with that name either. All right, counsel, please enter your appearance and give me your recommendation.
My name is Kerry Johnson, here for the defendant Malik Lott. Your Honor, I also spoke with the alleged victim, and she confirmed what the counsel just said. There was no violent contact whatsoever. It was basically an argument that went awry. And my client's just finding out why he's here, to be honest. He went to he went to work on start a new job on Monday. He went to orientation, planning to start the job on Tuesday, went home, and she came to his house. Miss Lamaya came there, and wanted to collect an item from him, an Xbox, I believe it was, right? PlayStation. And he didn't give it back. She called the police and, they explained to her that's not how it works. She can't just show up and get that item. And they ran his license and he learned that there was a warrant for it. So he had no idea. He's finding out today. The council just gave the synopsis of what he just said as to why we're here. So I would also agree that a signature bond is warranted in this case. He has no prior history. His family is here. All of his family, mom, dad, aunt, uncles. As I said, he's been there all his life, and he's never again committed any violence on anyone, let alone the alleged victim in this case. And he's interested to get out as quick as possible so he can start this job that he was supposed to start on yesterday.
Well, that's a heck of a bad day. He lost his PlayStation and got arrested. And of course, the new job on Monday. After we get the resolution to this guy, I'm gonna go off, guys. I am very tired. So we'll see how it pans out for him, and then I'm gonna end the stream. Well, I'll give AVA her TREATS so that you guys get to see her before bed. Also, real quick, thank you so much, Shane, for the Cash App Super Chat. I really appreciate it.
Okay, I thought I heard Miss Banks. Miss Banks, are you here?
Yes, I am here.
All right, we need you to turn on your camera. If you wish to make a statement, raise your right hand.
Okay, give me 1 second.
All right, do you swear to affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right, you can put your hand down. Again, I'm most concerned with any concerns you have for your safety and desires for contact. What would you like to tell me?
I do still want to have contacts. I don't have any problems about any safety or anything. I still want to have contact with my child father.
Okay. All right. At this time, defendant is going to receive a $5,000 signature bond through the jail. He's to have no further violent contact with the alleged victim. And as a condition of that signature bond, he's to have no alcohol, no drugs, and no weapons. Is there anything additional?
No, ma'am.
Nothing further, Your Honor.
If I were, Your Honor, and I haven't even spoken to McCann about whether or not he drinks from shit that doesn't do with drugs, but there was no alcohol or drugs or anything involved in this. And there are no allegations of alcohol or drug use or anything like that. So if that.
I understand your objection, but it's the ruling will stand, and I do appreciate your advocacy as it pertains to that point.
Thank you, Your Honor.
All right. Best of luck to you, sir. Yes, ma'am.
Two charges. How are you going to break that down?
There's more than one. My calendar says one. Is there? Oh, criminal trespass. Okay, 4,000 on the family violence and 1,000 on the criminal trespass. My apologies, Ms. Bridgewater.
No problem, Judge.
All right. Best of luck to you, sir.
No, that's all I have. Make excuse, please.
Yes, you may. Take care. Have a good afternoon. Bye-bye.
Oh, I thought he was going to say something else. All right. Thank you, Salty Buddha. Do I dare? Buddha, I love you, Buddha. Buddha, I'm going to give Ava some treats. Buddha. Oh, I know that, sweetie. I know you're just trying to support me, and I really do appreciate it. You are an awesome friend. You really are. I haven't even gotten to read the reply email yet, but I just want you to know that you are an absolutely wonderful person. I love having you here, and I appreciate you being a mod. And I appreciate everything that you do for me. You are a very, very sweet man. I did post the Discord in the chat, but she's saying that her email, when she goes to use it, it says that her email's already in use, which, to my understanding, would only happen if you were trying to create a new login. If you're logging in with an existing login, you shouldn't be getting that error, Becky D. All right. She'll get her bedtime snacks so that y'all get to see her wonderful pup face. And then it'll be bedtime. See that little face pop up? Dang, she's so cute. You're so cute. Everybody loves you. Wait. You wait. You be gentle. Good girl. Savor it. I think sometimes you don't even taste it. Make those olfactory glands work. Get that sniffer working. Smell the bacon. You are going to ruin one of my favorite shirts. It's a thing. Wait. Look at you. You are so funny. You are so funny. Your dew claw is going right into my hand. Bet you's funny. Here you go. Oh, I see you, Earl. I see you. Hi, people in court. Oh, we have a Billy. People in court, I'm so happy you're here. Right on P schedule. Yes, People in Court has an awesome channel. People in Court, if you go back in the stream, you'll get to see my goof for today. Spent 3 hours editing, and then I exported part of it and I was going to go back and do the undo to retrieve the part that I wasn't exporting, and I was going to save it for later, but then my CapCut not responded and froze up, and I had to close it, and I lost everything. 3 hours of editing gone down the drain. Do you not like that one flavor? For real, you're that picky. You are that picky. It's not even one of the Meow Mix ones. It's got to be one of the catnip flavored ones. He does not like the catnip flavored ones. Earl does, though. And so does Ava. Okay, buddy. I know you didn't get second dinner. But only 10% of your diet is supposed to be made up with treats. No, you don't get the bag. You get what's in my hand. You don't go for the whole bag. I tell you, these kids. And then it's going to be Earl's turn, and you've had enough. It's all gone. I love you. No, you stay away from that bag. Come on, Earl. It's your turn. Come on, sweet boy. So shy. Come on, baby boy. No, Billy. Earl. Come on, baby boy. Look. There you go. Yeah, she would. If I didn't make her slow down, she would just swallow it whole. You get a couple more. Yeah. I know there's some catnip ones there. I can tell by the color difference. The catnip ones have a greenish tint. He's such a messy eater too. Like he drops chunks all over the place. Billy and Ava don't mind. They retrieve them. You want to get your crumbs? You want your crumbs? Or are those going to go to the other cat? You're too cute. No, you're too good for crumbs. But watch, if I put an actual treat here next to those crumbs, let's see what happens. So now we've got an actual treat next to the crumbs. Now what? Now what? More crumbs. And he probably is. He's probably like eating them in a specific order. Like, you know how some people sort their M&Ms? That's Earl. That's Earl. I love you. Okay, Billy. Do you want the crumbs? Billy, come here. Do you want these? You gotta come here for them. Them's the rules. Ooh, he's thinking about it. He's thinking hard. He is thinking. Do you want them or not, Billy? Or do I give them to Ava? Ava gets them in one swift lick. It's like practically an extra treat right here. Like, it equivalates to a full treat when you stack all them crumbs together. Yeah. Put a treat side by side it. Yeah. That's a whole treat. Yeah, see? Actual treat, crumb treat. Yeah. Whole thing right here. Oh, you're too good for it, you distinguished gentleman. Okay. You know what that means. You gotta come around. Come on. Come on. Up. Not that hand. Well, okay, yeah, you can lick the hand, but one lick, that's all it took. One lick and it was all gone. All of it. She's like, yeah, and more. Aww. people in court, I was just thinking about grabbing, we got Domino's tonight and I ordered the spinach and feta stuffed cheese bread. And I was just thinking of grabbing half of a piece before bed. But I don't know if I want to do that because I got to put that BiPAP mask on. And I don't really want to eat something heavy garlic right before I put my mask on. That doesn't sound like a fun time. It's freaking chicken. Oh no, I liked the first version. I like that much better. Wolfant. Oh, I did not see the first one. How to eat an elephant. Oh. Okay, guys. All of the animals are fat and happy. So is their mama and grandmama. I am going to go to bed. Yup. I told, yep. Gotta go potty, Buddha? Buddha, gotta go potty? You gotta go potty, go Buddha? Ava's trying to figure out who Buddha is and why I'm taking Buddha potty. Oh yeah, I started at 11:30. I've been on for nearly 3 hours. Yeah, the red-bone coonhound. Yep, that's my girl. And I told you, I lost like 3 hours worth of work. I lost an hour worth of court that I had edited and that I can't get back without editing again. I know. How dare I have another dog at the house and don't tell her? How dare I take someone else's potty? Look at her. She's going to sulk now. It's okay, Ava. I love you. I love you, good girl. No thanks. No thanks at all. No. Mm-mm. It's bad enough when I have one that gets the leftover macaroni. All right, guys. Y'all behave. Be safe. Be well. Sleep sweet. And much love.